it is.
Has your students played it in class?
Once, and I asked them to please turn it off.
When they were listening to it, did they think that was fact?
No,
So they didn't think that that was depicting anything in real life?
no,
So you didn't have to teach them that wasn't real?
right. No, I did not.
You've heard the song, correct?
Yes.
Do you believe it's a literal interpretation?
No,
Would you agree it's derogatory towards women,
no,
even though it says nasty things about them?
yeah, no. I mean, it's the artist's opinion, I guess. That's the way I feel.
Maybe not an opinion you like, but
Yeah.
Your Honor, if I may have a moment.
Go ahead.
So, Ms. Grooms, has Mr. Foreman's posts about Sean or any of the general posts about the Adams County Sheriff's Department as a whole affected your life any at all?
No,
Would you believe it would have affected your life while you were married to Sean?
if it had any effect, I guess that would be the time it would have an effect.
But as his spouse, you would have expected it.
Yes.
And I don't want you to go into too many details, but is it fair to say that Mr. Foreman, the posts about the police department, everything had not a damn thing to do with your relationship between you and Sean and why it came to an end?
No, it did not.
So the posts never affected your life, never affected your marriage.
No.
Okay. So any statement to the contrary would be false?
Yes.
Okay. Thank you very much. No further questions at this time, Your Honor.
Cross-examination.
Thank you.
Morning, Ms. Grooms.
Good morning.
I'm sorry you have to be here.
I am too.
Thanks for coming. Where to start? You never sought a protective order against your ex-husband, did you?
Yes, I did when we divorced. The divorce, yes. I
Did
had a
you-
restraining order.
Did you got a restraining order?
Yes, I did.
Were you aware of the posts that were coming out after 2022 about the sheriff's deputies and calling them thieves and that sort of thing? Did you ever see any or hear any of the songs?
Some of my students referred to it and they would say, I saw your husband in the video. And I would say, yeah, that was him, and turn around and walk away. I didn't elaborate on any of that, no. And
Why?
they didn't either,
Why didn't you elaborate on it?
because I didn't think it was the student's business.
Okay, so they had seen your husband in videos,
Yes,
and did you tell your husband about that?
about,
That your kids had mentioned it?
no, it was just a mention and that was it.
Okay. Did you ever, you saw the posts yourselves or videos yourself, or did you just hear about it from kids?
I saw part of it and then I heard about it.
Okay. And did anyone else in the community ever say anything to you about these videos or posts?
No.
Just your kids?
It's my students in the school.
Students? Okay. The song that Mr. Osborne asked you about, does that song refer to a specific identifiable person?
I don't think so.
Those are all my questions. Thank you, ma'am.
Rhonda, Mr. Klingler asked you about your students. Your students saw the post
Yes.
and they articulated to you?
Yeah. Just say, hey, I saw your husband in this video.
Students can, would it be a fair statement to say children can be mean? Cruel?
Absolutely.
You've seen instances of them being cruel?
Absolutely.
Are they cruel to both other students and teachers?
Yes.
I don't like bringing up sensitive subjects, but has any of your students ever been cruel to you in the past?
Oh, yes, definitely.
Would it be fair to say they've said some pretty mean things?
Yes.
You see, I'm trying not to ask you what they are, but are they shocking names?
Coming from my students, I mean, in all honesty, it's, when they're mad at me because they didn't receive an A, yeah, they get mad.
And they
And-
lash out.
Yes.
But they're not calling names of fact or anything. towards
No.
you.
No.
And they've seen these posts.
Yes.
Did your students treat you any differently?
No.
So could you point to any instance where a student treated you differently due to the posts?
No.
I'm going to ask this question. You said you're sorry to be here. Why are you sorry to be here?
Because from my recollection, my ex-husband had said that this was part of the reason we got divorced.
No further questions, John.
Klinger?
No further questions.
Mr. Osborne, am I right to understand this witness was a lay witness?
Pardon me?
This was a lay witness, not an expert, right?
She's a lay witness to testify to what she would have experienced.
And the only reason I did that is to explain to the jury that people sometimes have training experience and can make opinions as experts. The doctor comes in a medical malpractice case, they're an expert. This is a lay person, the same as any other. Some of the questions spoke generally about society and public perception, which would seem like more of an expert opinion, when in fact, as a lay witness, she can only testify about what she experienced herself. So you have to understand the scope. She's just what happened to her, lay, average person, not educated expert. Thanks for being here. You can
Thank
be excused. Go ahead, Mr. Osborne.
Your Honor, I'd ask for a short 10-minute break so I can talk with Mr. Foreman. Based upon the ruling in the Rule 50, I want to juggle some of my witnesses, make some corrections to that, as I had anticipated a different verdict due to the evidence, or different ruling due to the evidence. So I'm going to need to shift for that. I'd like 10 minutes to consult with my client to strategize on that.
Comments, Mr. Klinger?
No, I have no objection to that, Jim.
If you're doing well managing your time, I think that's a good idea. I would like, how I'm doing with getting the jury on schedule.
Your Honor, that's why I want to strategize, see how we can hopefully.
Yeah, no, I appreciate what you're saying. Take a break, go back to the jury room, stay there if you would please. Short break will be helpful.
Joe, follow me up, please.
Excuse me 1 minute. Folks, I'm going to show you these forms that you're going to be filling out, just so you're familiar with them. This is just an example. You're going to have a different form for each of these plaintiffs, okay? This one happens to be a verdict form for Lisa Phillips. And I believe the evidence is overwhelming that you'll find in favor of Lisa Phillips. This happens to be her false light claim. There's a separate claim for defamation, a separate form for defamation, and you'll see the jury instructions. Judge Hine has already talked some about that with you. So this is just an example of the verdict form that I'm going to ask you all to sign in favor of Lisa Phillips and all of the plaintiffs on their false light and their defamation claims. Now, there's another form called an interrogatory. And I'm just showing you Lisa Phillips's form. And it says, we, the jury, find damages for plaintiff as follows. And then it gives a little description of the kind of damages. And there's a line for your decision, and there's signature lines for each of you to sign. For Lisa Phillips, I'm not going to show you every form. For Lisa Phillips, folks, I'm asking you to put $1.5 million in that verdict form. $1.5 million for Lisa Phillips from what she's been through for 3.5 years. Maybe going through for who knows how long. For Brian Newland, I'm asking you to issue a verdict for $1 million for what he's been through with his family, the loss of his dream job here in Adams County. For Randy Walters, I'm asking you for a verdict of $1 million for what he's been through with the allegations and vile videos about his wife. For the other 4 plaintiffs, Sean Grooms, Sean Cooley, Justin Cooley, and Mike Estep, I'm asking you for a total for all 4 of them of $400,000 divided among them however you see fit based on their testimony. You, of course, can award less. You can issue a verdict for more. That's what I'm asking you to say in your verdict form based on this testimony. Now, let me close my remarks by looking into the future here and looking at the future if there's a verdict for the plaintiffs and you award the plaintiffs a fair amount of money. What happens? The plaintiffs are vindicated. The court of public opinion out there, the press, which I know you haven't been looking at, they don't know the facts. You know the facts. And a verdict for the plaintiff will say they were wronged, he was wrong. A verdict for the plaintiffs will make up in some way for what they've been through. A verdict for the plaintiffs will say that we don't condone, we don't approve, you can't get away with what Mr. Foreman's done. Not in this community, not in this country. That's not freedom of speech where we live. That's what a verdict for the plaintiffs will say. Let's look at another possible future if there were to be a verdict for the defendant, or if there were to be a verdict with a small amount of money attached to it. In that case, in that world, in that future, the world is told what he did is okay. What they went through is no big deal. We don't really care. We think it's fine. That's what a verdict for the defendant or a small verdict would say. They would go home subject to even more ridicule. Yeah, you took him on and you lost. See what he did was fine. I don't have to tell you, you know, that's not the message we want to send. It's not the message you want to send. Folks, I'm done. I've done all I can. These folks called me 3 years ago now and asked, what can we do to stop this? And here we are today. I've done what I can. They've done what they can. They've suffered through the publicity. They could have stopped this case at any time if they would have kowtowed to the pressure, public humiliation that Mr. Foreman continued to put them through, but they didn't. They bravely stood behind their case and their right not to be drugged through the mud with lies in the media. They've done all they can. And now I am giving their case and this decision to you. It's out of my hands. You have to decide what to say to Mr. Foreman and what to say to the community about what he's done and the effects that it's had on these folks. I have full confidence, I fully trust you to make the right decision, to make a fair decision, and to come back with a verdict that's fair for each one of these plaintiffs and that tells the community what you really think about this case. Thank you very much.
Thank you, Mr. Clinton. You have like 11 minutes after that. Final. And Mr. Osborne?
Ladies and gentlemen, thank you for being here. This has been a long 3 days. It took a second for me to even count the number. It's been so long. A lot's happened. You've done your duty as jurors. You've paid attention to the evidence. I'm proud of that. What makes our country great is you have the right to have a jury trial. You have the right to people in the community to see this, weigh the evidence, and make a decision. And I'm proud that you guys are here and doing that. We started this time, I talked about this case was about freedom of speech. But let's talk about what it's also about. It's also about music. Not all music is tasteful. Not everybody likes all music. There's some songs I hate. I think we can find plenty of people that find songs they do not like. But Mr. Foreman, Joe, is a rapper and comedian. It's what he's done his whole life is rap, make songs. We got to think of what rap is, because music does not exist in a vacuum. Music evolves over time. Take a look at jazz. It's evolved. At one time, it was distinct in a certain subculture, and it has now expanded. Rap is the same. Rap started out as a means for people to express social commentary, opinions through entertainment. Look at the song by NWA. Or they call it Fuck the Police. I think I said that right. It's a social commentary on what was going on in their lives. Their personal effect, the personal things happening to them, combined with entertainment, which unfortunately is exaggeration. Opinion, nothing of fact in that song. It's a commentary on society. And so when you look at rap, you see that over and over again. I had my secretary print me a couple songs, rap songs, while I was pouring a cup of coffee. And the first one is Carly B, WAP. I find it bad to say what WAP means, but it's a popular song. I think it's somewhat derogatory, but then again, I'm not the audience for that song, and I know that. I know nothing in that song. Nothing talking about is true. I know it's not. I know it's entertainment. I know it's social commentary. Miss Grooms testified even her students knew that at a young age. The same thing I knew when I was watching Johnny Carson, The Late Night Show, and SNL, Saturday Night Live, with my grandfather when I was a kid. That's all entertainment. They make fun of everybody for entertainment. And some of it is a social commentary. But it is not fact. And everybody knows that. Nobody looks at Lil Wayne's song Pussy Monster and says there's a monster in that song. Everybody knows it's exaggeration for entertainment. Is he commenting on something? Sure. But it's not fact. And I can keep going. Megan Thee Stallion with sex talk. I mean, it just goes on. They use derogatory language. It's designed to entertain. Drew Hastings, former mayor of Hillsborough, was a comedian. I got to go to one of his stand-ups. Some of it was funny. Some of it wasn't. Some of his jokes, like those of Eddie Murphy and Richard Pryor, some of them are not tasteful, but they're still jokes. They're not facts. And we know that. That's what a reasonable person listening to that would understand. And that's the point. This is not a vacuum. We don't live in a vacuum. Let's face it, if we lived in a vacuum, we'd all be dead because we couldn't breathe. So we live in a world full of everything, where we see things. We watch SNL. We know it's entertainment. We know it's going to pick on people. We understand that they're picking on public officials. Well, they picked on Joe. They pick on Donald Trump all the time, Sleepy Joe. I mean, go down the list, even Teflon Ron was made fun of. So as you go back, nobody thinks that's fact. Nobody's going to take it that way. When they post their clips on YouTube, when they post their clips on Facebook, people don't look at it and go, that's the truth. No, they understand it's comedy. They understand they're going to talk about it going forward. And if you look at his posts, you see the little signs of that too. Iteration. Things that you see in a song. I mean, because after all, you know, a song's catchy, right? It has beat, song, you know, words rhyme. You know, she thinks my tractor's sexy and, you know, sticks with you. When we listen to Lemon Pound Cake, you heard the iteration. You heard how it came together as entertainment. So we don't exist in the vacuum, and a reasonable person doesn't exist in the vacuum. As the judge said, you are a reasonable people. You get to decide what's reasonable, which means you get to use your experience. You get to use your understanding of what those are, of your understanding of Joe, of your understanding of rap music, music in general. I'm not going to sit here and say that these 7 people were happy about what happened to them. I'm not going to say that. That'd be stupid. But what I am going to say is they are public officials. We see it on the news all the time, public officials made fun of. Let's go back to voir dire. During my voir dire, we talked about, with the one juror that's gone, we talked about that, yes, I ran for public office. She agreed I put myself out as a public official. She agreed that it was an opinion when someone called me a baby killer. Even our witnesses on the stand, I asked that question. They said a crooked defense attorney is not a vine, it's a matter of opinion. Crooked cops, dirty defense attorneys. Oh, wait, one witness did want to say I might not have taken a shower. But those are all opinions, exaggerations, not statements of fact. And we know that. And that's why public officials are held to a higher standard, because that standard is what is expected of them as subjecting themselves to public scrutiny. They all testify that people have criticized their work. I mean, after all, we look at the search. There is, even Mr. Newland admitted it wasn't perfect. I think we can see from how the money was handled, the investigation. I would have liked to have seen a more thorough job myself. I mean, we have a chain of custody, the money that just leaves it laying there. Mr. Newland didn't know that. We have an unsealed evidence bag. We have 10% of all evidence, money evidence in the Adams County evidence locker miscounted. And then keep in mind that that miscount on those is less than what is alleged to miss here. We got people saying we had a miscount, yet they can't even bother to notify the court in an official document that they made a mistake. Just let it ride. As far as the public record knows, which they never corrected, Mr. Foreman never got back all of his money. They want to talk about an investigation, but they can't even put in a single piece of paper to correct his mistake. I don't know if I'd call that lazy or what, but I think it goes to what you consider a fact. Because what is a fact? We can't always know what a fact is. Fact is something you can disprove, right? But can we truly disprove them? Looking at all the evidence, there is questions. If there's questions, it's not a fact. Now, people will form opinions based on that. I formed an opinion. I imagine everybody here's formed an opinion. We know that they formed an opinion because they didn't like being called a thief. So that was their opinion. But people are allowed to have opinions. People are allowed to express them. What people are expressing when they call them thief is not a literal statement. It is not a fact. It is a social commentary on the fact that they didn't do things correctly. And they can't even articulate how they could fix it. That is a social commentary if I ever heard one. They don't like it? That's not their choice to like it or not. They're public officials. They're going to be held to a higher standard. Their work's going to be criticized. I mean, that's just what happens when you're a public official. No reasonable person would expect a police officer not to be criticized. They've all been called names before. Has it affected them personally? Yes. Ms. Grooms testified it made no difference in her life. Her kids didn't take it seriously. And she's taught for damn near 30 years. But they seem to take it seriously. And I come back to Mr. Grooms. He's worried about going out on a call and being shot. Now, maybe I'm old fashioned, but if I'm going out on a call, I'm worried about getting shot. I'm going to call my wife and tell her to be safe, not sit here and go, I'm worried about me. That's not what you do. You take care of your family. Mr. Walters wanted to point that out. That just goes to show us he didn't take it seriously. Now, I'm not going to say they're not afraid. Anytime they go on a call, the highway patrol will tell you scariest things at traffic stop. You know nothing about the person. You're there by yourself and things can change in an instant. Is that scary? Fuck yeah. I'd be scared. But if you're truly scared, you take the steps for it. You start having your family do stuff. You start doing that. If you believe what you're saying, you take the steps towards it. He didn't take the steps. No one else talked about how they took the steps either, did they? And why does that matter? Because a reasonable person is going to look at that. After all, let's go back to me not taking a shower. How would you know I didn't take a shower? Hair clumpy, probably matted, probably got dirt all over me. That's how you would see. That's how you would prove if that's an opinion or fact. Now, even then you might say Dave just fell in the mud. But no reasonable person would take it in the vacuum. And I want you to think about everything in context. What rap is music, how it's entertainment, how the language works on it, how jokes are made. I want you to think back to it because that colors how you see it. I love picking on Joe. He's a good sport for it. Look at that suit. Does this look like a man who thinks that everybody's going to assume that everything he's saying is fact? I mean, he's like a comedian. He exaggerates for the sake of entertainment. That's who he is. I'm not going to say it's tasteful to everyone, but some people do find it entertaining. I asked an important question about them. I said, do you believe everything in the newspaper? No. Do you believe everything you read on the internet? No. We all know that to be true. A reasonable person knows that. People can post opinions, social commentary, and hurtful things all over the internet. And it is just to be expected. That's why we are supposed to use our own filter, use our common sense, use our experiences in life. So while hurtful, it was not fact. It was music, entertainment. Stuff that no reasonable person would understand, especially not a public official, because we see it on TV all the time. We see it on the internet. You see it on Facebook. Sometimes people want to turn off Facebook because there's so much political commentary and stuff. But that's expected. Do I expect everything I read is fact? I don't even think most of it's fact. I think it's everybody's opinion, and opinions are like assholes. Everybody has one and it stinks. But that doesn't mean they can't have it. That doesn't mean they can't express them, and that doesn't mean they can't make a song about it. Truth is a defense. That's why we talked about the theft. That's why we showed all that. Because I wanted you to see how the money was handled. There's a lot of confusion around it. And for that reason. Before I get to another point, I want to address something that's bouncing around my head. Bob says, what does this message send if you find for Mr. Foreman? I rephrase that question a little differently. What does this message send if we find that music and social commentary, while maybe not the most tasteful thing in the world, is silenced because a public official, while hurt by it, yes, unhappy by it, yes, pissed off, yes, emotional, yes, What opinion is that? I mean, if you can sue people, music artists, comedians to shut them down, that's what we're looking at here. I'm sorry they feel the way they do. But there's a certain amount that you have to take as a public official. It's part of the duties as a job. As we talked about during voir dire, as I've talked about them being called a baby killer, there's certain things you take and you move on. It's part of the job. The plaintiffs, or I should say Bob, talks about how they wanted it to stop. Where was the certified cease and desist letter? Where was all this done? None of that was done until after they started the lawsuit, until after they brought it to court to make it stop. It's what they wanted to make it stop, yet they asked for money. The commentary on them is nebulous at best. You can see that when you look at it. We have Beetle Bailey, Gomer Pyle, Colonel King Kong Bundy. Some of these names are not as bad as others, yes, but they're all for artistic purpose. They're all for jokes. They're all for entertainment. This is not to paint them in a real light. No reasonable person would think that. It's kind of interesting because even Mr. Newland agreed that when he was called a pedophile by Mr. Foreman, yes, that is a horrible thing to call a person. But even he said it was Mr. Foreman's opinion. So he didn't believe it was a fact. If your own witness doesn't believe it's a fact, how can a reasonable person find it's a fact? Bob went to great lengths to say nothing will stop him. Shows us where we're at. We got to stop his expression. We got to stop entertainment. We got to stop exaggeration. That's what Bob's talking about. What chilling effect does that have on the world we live in? Think about it. You don't like what a commissioner does. You don't like what our prosecutor does. You don't like what any public official does, and you make a joke, and you're drugging the court. It may not have been a tasteful joke. It may have been a bad joke. It may have been the greatest joke ever. But what we're saying is if they don't like it, we're back here. What does that say to you? Freedom of speech? What does that say to the world we live in? That's what this case is about. And Bob knows that. That's why he mentions it. That's why when you look at defamation and the jury instructions, you'll see that the first element of it is a statement. Portrayal of fact. Has to be portrayed as fact. No music video portrays as a fact. I don't watch Fuck Those Police and turn around and say, you know what, that's a fact. No. I say that's a song and it's entertainment and move on. Sometimes I try to figure out what the words mean, what kind they're getting at, but I don't expect them to present a fact. Fourth element is the proximate cause. It's an interesting question there because you'll get the definition of causation and proximate. And we never talked about that really during the trial. It's going to be something that I want to discuss. They talked about getting phone calls. None of those posts. Joe never said, call them and tell them this. Mr. Cooley testified that they mailed pound cakes to the office. Joe never said send them a lemon pound cake. These are things that other people have done. Joe never directed them to do it. He didn't cause it. He made a joke. He cannot control how people take it. What they do, he's not that. All he can do is make a joke, make a song. So that's something to consider. Was he the proximate cause, or was it someone else? I want you to understand when they get to the question of malice, if you get that far, it has to be actual malice. Public officials, it's a higher standard. Why? Because we hold public officials to a high standard. Let's talk about the false light. That's their second cause of action. That says that a reasonable person would be justified in the eyes of the community, feeling seriously offended and aggrieved. I want you to go in on the eyes of the community. They want to say people's humiliating them, calling them names. The reality is a reasonable person in the eyes of the community is going to say, it's a song. It's a joke. I was flabbergasted to hear it myself, that they even thought it was a joke before they brought the lawsuit. Go to a Halloween party and bring a lemon pound cake. That, I almost have no words for that, honestly, because I get, we're hurt, but it's a joke. Which one is it? So a reasonable person in the eyes of the community would understand it's a joke. Mr. Estep testified about the joke of the shirt. We got the pound cake joke. There's various jokes for this. This was not as negative. This has not changed their view in the eyes of the community, because your reputation, which is what they claim is hurt, your reputation is like a shirt. You eat a hot dog, you drop mustard on it, you get stains on your shirt. Nobody's reputation's clean. Everything you do affects your reputation. The way you perform your job affects your reputation. They all admitted to that on the stand because I asked that question. They all said it does. How they counted that money affects their reputation. People can form opinions based on how they did their job and criticize them on it. That's a right we have. You have to forgive me, I have to flip through these, son. We didn't have a lot of time to prepare as things change on the fly. I think as you go back and deliberate, take a look at all the exhibits, analyze it in the context of music, entertainment, opinion, social commentary. It's not a fact. And if you look at it, you can see that. Like I said, it may not be tasteful, may not be nice, but even SNL is not nice. South Park's not nice. These things are social commentaries, jokes, entertainment, and some of them are not nice. But you don't have to like everything. You don't have to like everything said about you, and you don't have the right to tell everybody that everything said about you should be sued for, especially if you're a public official. As such, I ask you to deliver a verdict in Joe's favor on all claims. I ask that because when you look at it, no reasonable person could see it as a fact. No reasonable person could see it as even false light. The community, if they called them, if people called them, that's because the social commentary resonated with someone, resonated with what people experienced in the world. We've lived through a turbulent year, so we've all seen on the news what people are experiencing all over the country. Social commentary resonates because of that. That doesn't make him the proximate cause. That shows a deeper concern in our country that we should be addressing, not sitting here trying to decide if a music video is a fact or not. That's what's at issue here. And I'm confident as you go back in deliberations, you'll come to that conclusion too. And with that, I thank you again for your service, because it is not easy. And what you're about to do is not easy. It takes time and deliberation. It takes hard work. And I appreciate that you guys are willing to do it. And I reiterate again, that's what makes us a great country. Thank you very much.
Mr. Osborne? Go ahead, Mr. Plaintiff.
Thank you, Your Honor. Nothing Mr. Osborne said about sexually explicit songs out in society refer to specific people in the community, like the songs that are at issue here. It's not the same thing. We all know that. These weren't opinions. Mr. Foreman didn't say, in my opinion, Brian Newland is a pedophile. In my opinion, they're all thieves. In my opinion, I fucked his wife doggy style. He said it like they were facts. And I think Judge Hine is going to instruct you, based on everything that's happened so far, that these were not opinions. They were stated as fact. And your job is to decide whether those facts were true or not. And we know they're not. The case isn't about lemon pound cake. It's about intentional lies designed to hurt people, and they hurt people. If somebody in the jury room says, well, what about his First Amendment rights? You know, and the law tells you, that doesn't allow lies that hurt people. If someone tells you it's just artistic expression, he ought to be free to say what he wants, the answer is he's not allowed to wrap up harmful lies into songs, so-called art, put them out there and get away with it. The packaging of the lie doesn't make it okay. The message was clear. And Mr. Foreman doesn't get to wrap himself in the American flag and say, you can't touch me. I can say what I want, no matter how untrue it is, no matter how much pain it causes people, no matter for how long, because I have freedom of speech. He can't do that. I'm confident you'll tell him he can't do that. Thank you.
Thank you, Mr. Plaintiff. Let me acknowledge Mr. Osborne.
Your Honor, I didn't mean to interrupt you. One thing is I was going to ask before we read the jury instructions, if I could use, if we could restroom break for that, because I know it's going to take some time to read it.
Everybody's gonna stand in their seat and stretch. Nobody's gonna leave the room but you. Because you're pretty prompt with that, so go for it.
Thank you.
I'll just stand up. Blood flowing. Well, you're in my team. what we call remoteness. It gets more and more unreliable the more remote you get from the first circumstantial evidence. If you want to say the circumstantial evidence is reliable, great. If you want to infer that that's reasonable, great. But don't stack another, well, now I suppose something else happened. And if that happened, then something else should have happened. It's stacking, it's called remoteness. Then it gets unreliable. With regard to the exhibits, you saw exhibits, there was testimony related to them. Consider whether the exhibits are in fact what they're portrayed to be. You decide what weight, if any, the exhibits have to have when thinking about the testimony involving them. Exhibits in video can speak themselves, but sometimes paper and other exhibits don't. So you have to consider what the witness said in light of how the exhibit was portrayed. Don't make inferences or conclusions based upon the number of exhibits. Remember, I want you to look at the quality, not just simply the number. Like theoretically, the plaintiffs had more number of exhibits than the defendant. Don't care, don't count numbers. Look at the quality, make the content important. You'll have like physical, tangible paper exhibits back there. When you get to the video or the data-driven exhibits, you'll have a computer back there so you can use that to look at the exhibits. So if it never works that way, so I always offer the bailiff services that he can come back and, as you saw, make the technology work. So if you struggle back there with plugging in a thumb drive and finding the drive and then turning it on, we would expect that. I'll tell you how to communicate with us, but just ask for help. We'll send back a very capable bailiff and he'll save the day. Evidence is not what the lawyers say. You heard opening statements, closing arguments. That's not evidence. It's helpful, it's necessary, it's built into the system, but it's not evidence. If a statement was asked and the question was not answered, there's no evidence from the question. I did that once or twice to show you how it works. Just, you might have thought the answer was going to be yes because the witness was shaking their head yes. The witness was, yeah, I understand the question, and the answer is no. So you can't use body language to get an answer that wasn't spoken from the record. I don't think that happened too often. But remember where the evidence is. It's the exhibits and the witness statement, not the lawyering side of the case. There was times where I sustained objections and handled the lawyers the way I thought was necessary. I always ask people to apologize or accept my apology if you thought how I handled the lawyers is any kind of a comment upon the quality of the case. Like, I try not to do that. But you might misunderstand that in scolding a witness or handling a lawyer, I was expressing an opinion. I love it when you guys show up because I don't have to decide. It's like I always try to make sure I'm neutral in my facial expressions and my voice tone, but sometimes I just don't get that done. An important role for the jurors is to weigh credibility. Credibility is assigning believability, assigning weight to the evidence, assigning weight to the witness testimony, assigning weight to the exhibits. When you weigh evidence, you're basically deciding truthfulness. And as odd as it sounds, it's what we do all the time. We weigh credibility continuously each day. In weighing credibility, you should consider the appearance of the witness on the stand. Consider the manner in which they testify. Did it seem straightforward? Did it seem honest? Did it seem evasive? What did it seem to you? So you're using your eyes and you're using ears to weigh credibility. Think about how reasonable their testimony was in light of the subject matter of the trial. Consider education, interest, bias. Consider if they were frank with you or not. We use these tests every day to decide whether we want to rely upon or find a person believable or not. As I told you before, every witness took an oath to be honest in their testimony. The oath does not bind you that just because they're talking, I have to believe it. In fact, you have to parse it out because people could very honestly get up and say, I believe this to be true, when in fact they're misunderstood and wrong, not lying. So recognize you can parse the evidence. You can believe everything a witness said. You can believe nothing a witness said. You can pull out the pieces you think are credible and ignore those that you think are not credible. And then you shuffle that entire deck with every witness along the way. As a rule, we want people only to testify, general rule, about things they heard and experienced and saw, firsthand testimony. So that's the general rule. But then we violate that general rule because we let people express their opinions about what the facts or circumstances mean that they experienced. So in deciding what their opinion means and how you weigh their opinion, you do the same thing. You're allowed to hear their opinion. It's evidence. But you have to, again, parse it out in terms of the credibility test. A person can give you an opinion, and you might go, I don't believe that because that's not in their subject matter, or they don't have enough knowledge, or their emotions got the better of them, or they have an interest or a bias or whatever. And you might go, no, it's a completely valid opinion because of whatever credibility factors you have. So we give you direct testimony, we give you circumstantial, we give you opinions, and then tell you to weigh out those things that you find believable, credible, and otherwise. In this process, the jury sits around as a committee. And it might be that you find a person credible, the other person finds somewhat credible, and the other person finds not credible. Expect that to happen. And then resolve those differences back there. There's more about that later, but in this whole deliberation process, that's normal. Somebody said while they were here, yeah, I'd served on jury. No, it wasn't easy. It's not meant to be easy. It's important. I just have to explain the rules enough and then tell you don't get your feelings hurt when you get back there and begin the discussion. The instructions I gave you so far would be relatively common in most trials because those are general rules for how to do the job as a juror. The next set of instructions in the middle, I call substantive instructions. These are the law that applies, the rules that apply to this set of facts, these claims. You'll have sets of these instructions to go back over. So I have to read them to you in the party's presence, but you're not expected to remember all this. You'll have your opportunities to go back over it and get schooled later. So these are the substantive instructions. Again, two claims. One's called defamation. The other's called invasion of privacy based upon this false light publicity. They have separate instructions. I put them right next to each other, but the rules for the one claim are not the same as the other. There's overlap, but they are a separate set of rules. So don't apply the rules for defamation to the false light publicity claim because you went across the line of their two separate causes of action. With regard to defamation, each plaintiff claims the defendant defamed him or her that then caused them damages. To establish defamation, each plaintiff must show that a statement, that could be oral, written, video, was portrayed a fact that was published. So the statement was made, or statement of fact was portrayed and published. Second, that the statement was untrue. Third, that the defendant acted with malice, actual malice, or reckless regard for knowledge of the truthfulness, and that they suffered injury. I'm going to break those four apart. Okay, so again, the statement was portrayed as a fact. It has to be published, so that's all rolls together. That the statement was untrue. The defendant acted with either actual malice or reckless regard about the truthfulness of it, and then that caused injury. Plaintiffs are considered public officials. You heard a lot of that. So that's where the clear and convincing evidence standard applies. So what you're doing is taking on the element of the defendant acted with malice or reckless disregard about the truthfulness of it. That's the higher, clear and convincing proof. So on that element, it's not just a preponderance. On that third element, it's thoroughly convinced about his motive for publication. Clear and convincing evidence means you're thoroughly convinced about the truthfulness of motive for making or publishing the statement. What's actual malice? This knowledge in the publication. Actual malice occurs when the defendant makes a false statement with knowledge it's false. The second part of that test, it's either published with actual malice or published with a reckless disregard about the truthfulness or not. So reckless disregard means that a defendant acted while aware that the statement was probably false, or that the defendant entertained serious doubts about the truthfulness and didn't inquire. The defendant's failure to investigate may be considered evidence of reckless disregard or evidence of falsity when the defendant had serious doubt about whether it was truthful or not. So actual knowledge of falseness or reckless disregard about something that's probably false. Those elements have to be proven by the higher amount of evidence. A statement is false when it's not substantially true. It's substantially true when the essence of the statement is true, when you think about the statement as a whole. The defendant's statements or portrayals must be given their ordinary meaning in that context, in that circumstance. So you can't just pull a line out. You have to look at the whole portrayal of the statement. In deciding whether the statement is false, you're not to consider the defendant's subjective belief. You consider whether it's true or false from an objectively reasonable perspective. So it's your perspective about truthfulness, not what the defendant thought at the time, because we can all think of things that are unreasonably thought. So we apply an outside standard, an objective standard, not the defendant's subjective belief. Now, this idea about the concept of truthfulness is where we find the fact that truth is a defense. So if the statement is true, then there can be no defamation. Plaintiffs also have to prove that the statements were published, portrayed, made. Published means that the statement was read or heard by another person other than the plaintiffs. From the testimony, as a matter of law, the courts has determined that publishing or portrayal is not an issue. Nobody pushed back. It's not anything you have to decide. I'm telling you as a matter of law, that element is uncontroverted, that the defendant published, the defendant portrayed the statement. So of those four, one's been resolved by the court because there's no contrary evidence. Now you're down to analyzing those three statements, elements, if you will. You need to know how to differentiate between facts and opinion. In a defamation claim, this is important. This is over on this side of the first claim, fact versus opinion. The distinction between portraying a statement of fact and portraying a statement as opinion is crucial. It's an important distinction. Portraying a fact or portraying an opinion. Only statements of fact can be the basis for a defamation claim. Statements of fact could be untrue, which is the nature of a defamation claim. If I'm expressing an opinion, there's no way to decide whether it's true or untrue, so you can't defame someone in expressing an opinion because there's nothing verifiable about it. It's an opinion. So a defamation claim has to involve an untrue fact. To determine whether a statement is fact or opinion, you apply these four factors in their whole context. You look at the specific statement, the language in the statement. Consider, importantly, whether that statement is verifiable or not. Then apply the general context of the statement, and then think about not only the context of the statement, but then the broader, how the statement could be received or heard. Start with the statement, is it verifiable? Consider the circumstances of the statement in its context, and then go farther out to the statement's circumstances in general. Look at the precise wording. Determine whether a reasonable hearer or listener would view the words as portraying fact or portraying opinion. If a statement is made and it's considered an opinion because it's not verifiable, there could be no defamation. If a statement is made and it contains verifiable information, then it can be the subject of a defamation claim if the verifiable statement is untrue. If you find that the statement was portrayed to the public as a fact, that the portrayal was false, it's a fact that it's false, plaintiffs have proven their case. If you find that it's not a fact, or that the fact was true, then the defendant prevails. This is why I give it to you in writing.
Okay, I forgot about that.
General instructions for defamation are done. Those rules apply to that claim. These rules apply to the invasion of privacy false light claim. There's only one place where I'm going to tell you to overlap the instructions. So don't overlap all the first instructions in the second bucket, separate set of rules. The person who invades the right of privacy of another person can be subject to liability and the harm that comes from invading that other person's right of privacy. The right of privacy is the right of a person to be left alone. It's the right to be free from the unwarranted appropriation or the exploitation of a person's personality or their private affairs in such a manner as to outrage or cause mental suffering, some sort of shame or humiliation to the person. Each plaintiff claims the defendant violated his or her right to privacy by publicizing false information that places them in a false light in the public. Each plaintiff must prove that the false light in which they were placed would be highly offensive. It's a highly offensive place to a reasonable person, not their subjective, but would a reasonable person find that they were put in a highly offensive place. And the defendant had knowledge of or acted with reckless disregard to the falsity of the publicized matter. Reckless disregard, falsity, and actual knowledge are the same definitions from the first section. So that part of the first instructions you can carry over. Actual knowledge, reckless disregard, and falsity, I'm not going to redefine. That part you would read over. But it's a different test. Was the particular plaintiff put in a false light by the false information? False light means the defendants know that the plaintiff, as a reasonable person, would be justified in feeling seriously offended and aggrieved by the publicity, seriously offended and aggrieved by the publicity. The plaintiff's privacy is not invaded when it's an unimportant statement that's made. It's only when there's such a major misrepresentation of the plaintiff's character, history, activity, some fact, that it might be reasonably expected that a reasonable person would be highly offended. Determine whether the statements made by the defendant would place a reasonable person in a position of false light, not merely whether the plaintiff believed they were in a false light. So this is the objective perspective that we use for juries. You're the outside public looking in. Do you consider it reasonable or not that they would be highly offended? It's not their subjective belief, it's the public's perception. To be highly offensive, the plaintiff must be justified in the eyes of the community as feeling seriously offended and aggrieved by the publicity. The statement must be such a major misrepresentation of their character, of their history, of their activities, of their beliefs or facts about them, that they would be seriously offended in the eyes of a reasonable person of the public. False has the same definitions I gave you, not substantially untrue. The fact versus opinion distinction doesn't apply from that, so you don't have to do the fact versus opinion analysis. If you find that any one or more of the plaintiffs proved all the elements of false light, invasion of privacy, then you would enter a verdict in their favor. If you find that any one or more of the plaintiffs did not prove all the elements of false light, invasion of privacy, then you would rule in the defendant's favor. I'll say it again, there's 7 determinations on false light, there's 7 determinations on defamation, and you make them separately. If you find for a plaintiff on either one or both of their claims, then you go to the question of whether the defamation or the invasion of privacy caused damages. There always has to be a connection between the false statement and the damage, or the false light offensive position they were put into and the damages. A person who seeks to recover damages must prove not only that the other party caused the harm, but also that the conduct proximately caused them injury. Proximate cause is an act that in its natural and logical sequence caused the injury. There was an example of the defendant could have caused, but was something else actually the cause. You have to sort out whether the person's injury came from the defendant's conduct or came from somewhere else. With regard to damages, the purposes of damages are to compensate a plaintiff for injury, to their reputation for any kind of monetary loss, for emotional distress, so it's compensation, to vindicate the plaintiff, which helps restore their reputation, and to dissuade others from publishing defamation statements or false light statements. If you find that any one or more of the plaintiffs' claims should be ruled in their favor, then you have to have the greater weight of the evidence, a preponderance of the evidence about the amount, not clear and convincing proof about damages, but in your deliberations, slightly more evidence in favor of the amount to award is the test, the burden of proof. Take into consideration all the facts and circumstances and evidence, decide what amount of compensation should be awarded to each particular defendant or plaintiff. These are the kind of types or examples for which you can award money. Harm to their reputation, including exposure to public hatred, public contempt, ridicule, or public scorn, and or loss of professional income and or out-of-pocket expenses, and or physical, mental anguish, pain, and suffering, loss of society, companionship, and friendship. Those are all eligible factors or categories by which to compare or measure damages. It could be that the award of damages is not easily determinable and you can't put an amount on it. You can still order what's called nominal, or I'm going to use the word token damages. So if you find in favor of the plaintiff, then you have essentially the opportunity to go from 1 to wherever. Nominal or token would be the 1 or 10 or some low amount as a statement that they prevailed and entitled damages, but you're not bound by anything more than 1 in your deliberations. But if you find for a plaintiff, then there has to be an award for damages, assuming there's a causal link between the defamation or the false light and injury or harm to reputation, emotions, etc. As a matter of law, the court determined previously that the claimed damage to the defendant's home was permitted under the circumstances of serving the search warrant. Therefore, you do not make a reduction for any damage that the defendant said happened to his home during the search warrant. The court previously found, as a matter of law, that that's expected or permitted as a result of serving the search warrant. So you don't subtract based upon whatever you think happened to his home. In your deliberations, a plaintiff cannot have double recovery. If you find defamation and invasion of false light privacy, you don't issue an award under each category. You can't award pain and suffering, say this, emotional distress once and then emotional distress twice. You would issue one order as long as there's either a claim for defamation or a claim for false light, invasion of privacy. Don't double up if a plaintiff prevailed on both claims. Your verdict form doesn't really make that possible. You'll get there, we're getting close. Another concept that came up earlier was something called punitive damages. You are advised that punitive damages are not a part of the deliberations given to you right now. I haven't talked about punitive damages. Punitive damages are meant to be punishment damages for conduct. That's not a part of your deliberations. You're deliberating what we call compensatory injury-related damages. An award of punitive damages can only be given if there is a compensatory damage award. If a compensatory damage award is given, then you come back with a different set of instructions and you have arguably a second deliberation about punitive damage. You'll have to award it, but they aren't all lumped in. So don't think in this first phase, oh, the punishers are really mad. That's not where we are. If you find any plaintiff prevails on either claim and it caused injury, compensatory, actual repair damages, if you will, are what we're here for, not punishment. That's a second deliberation. The verdict forms aren't that hard to understand once you know what you're doing. Each plaintiff has 3 pages. Page 1 is the claim for defamation. We, the jury, being duly impaneled, find in favor of, and then it says Sean Cooley or defendant, circle 1. So you have to circle whether the defendant prevailed on Sean Cooley's claim for defamation. Then there's signature lines. Regardless of that verdict, you go to the second claim. So the next form is we, the jury, find in favor of Sean Cooley or defendant for the false light claim. The instructions at the bottom of each page say, now go to the next page. If you find for that plaintiff on either of the first 2 forms, then you go to form number 3, which is damages. Damages is 1 line where you put a number in. You can take notes and you can split it out. You can do calculations. You can decide how you get to it. But there's 1 line. So that would be for Sean Cooley. And it says Sean Cooley on the first 3 pages. And then the next 3 pages say Justin Cooley. Same 3 pages. So the first 2 pages find in favor of that plaintiff or the defendant, circle 1. Next one, in favor of that plaintiff or defendant on the second claim, circle 1 of those options. And then you go to the damages form only if the plaintiff prevailed on one of the first 2. They're all numbered, they all have names on it. They should be easy to follow. You can tell me later. What do you do when you go back there? The first thing you officially need to do is pick a foreperson. Now the foreperson is not the shop foreman, they're not the boss. They don't tell you what to do. The foreperson job is to organize the discussion engage people, keep track of the exhibits, be the committee chairman. But the foreperson doesn't convince you to do what they want. They organize the discussion. There's no way to pick a foreperson. You can arm wrestle, throw fingers, draw names out of a hat. Don't go to the bathroom first, because you very well could come out the foreperson. I don't care. I've heard people say that. They pick them because they weren't there. It doesn't matter. I can't tell you how to pick one. Just get one. Throwing fingers is fine. It takes too long. You probably already know who's willing to do it, or maybe you've talked to each other enough, or you just say, sorry, you lose, you're it. But it's just organizing discussion. That's all it is. Just organize the discussion. Make sure nothing leaves. You'll have in your possession the verdict forms, the exhibits. You'll have copies of these instructions. Keep all that back there. When you come out, the only thing left to bring back out here should be all these verdict forms. Leave your notebooks back there. Everything else in the foreperson should make sure that goes on. How do you deliberate? Generally, the advice to you is to go back there and start talking about the case, replay the witnesses, but don't just say, I think something ought to happen. When you come out with your first opinion and then start discussing it, a lot of people realize their first opinion is not their best opinion. But once you threw it out there, then you got to figure out, how do I get my pride back and retool? So generally, don't go back there and just say, here's what we ought to do. What do you think about this witness, and how did this one come across? And do you understand the rules? And start into this discussion process, however you can do it. But eventually, then you're going to need to start getting to the point where you see a consensus is being built. If you immediately express an opinion, changing is sometimes hard, so work together to build a consensus. Consult with one another in the jury room, deliberate with a view of reaching an agreement. You can do so as a group, but without surrendering your own conviction. Each of you ultimately has to decide this case for themselves in this deliberation process. You might find somebody leaning on you to change your opinion. That's good, unless you feel pressured against your will to change your opinion. If they come at you with good arguments, maybe you should rethink your position, because their arguments really are good. So like a certain amount of give and take and tension is usually the sign of a good deliberation. Just don't take it personally. Never surrender your own personal convictions just to get along. Don't be influenced by considerations of sympathy or prejudice. The law does not expect us to be robots and have no sympathy, no emotions, no prejudice, or no biases. That happens all the time. You have to set those aside. You're required to disregard them, to make your verdict carefully, to weigh the evidence, consider disputed questions of fact, apply the law to try to reach a verdict which the parties would be considering fair to both sides. Fairness is a big thing. Is this verdict fair to both the parties? Consider all the evidence regardless of who brought it forward. Do so with intelligence, impartiality, without bias, without sympathy, without prejudice. During the deliberations, if you have questions, you're welcome to write them down, which then comes to me, which goes to the lawyers to get you an answer. Like a magic doorbell. Knock on the door. Okay. The bailiff's like within earshot. He doesn't have his cup up against the door. So like pound on the door enough to get his attention. He'll come back, get the question, give it to me. I'll huddle with the lawyers, get you an answer. So when you get back there, there's a problem. You don't understand something, you want more information, you can get more information. Like we'll try to make sure you're not starving, like creature comforts will be provided. Like we're going to run into the lunch hour, so there's a way of taking care of it. I heard it yesterday, they'll do it today. So like we're going to want to cover all those bases. The clock is yours when the deliberations start. You watch me pay attention to the clock, right? I don't have a clock because you do. So how much time you need is up to you, not up to our expectations or our time commitment. We got to make sure that when you deliberate, you don't do so out of like human denial or fatigue. So yeah, we're going to watch to see how that goes. Like you might have me send you a question saying, is everybody fine? Are you awake? Do you need coffee? Do you need food? What do you need? One jury kept going, my personal record's 1:24 a.m. because that's what they wanted. They didn't want to go home. They were not coming back tomorrow because they were locked in and doing a good job. But it wasn't my clock, it was theirs. Until the verdict is announced in open court, you cannot indicate to anybody what it is. When you knock on the door saying we have a verdict, the bailiff will come, he'll tell me that you have a verdict. The foreperson brings the forms out here. And you hold on to them till everybody's here, and then we open the verdicts in front of all the parties. Don't say, oh, so-and-so, and this is the outcome, because the bailiff doesn't want to know that, and he shouldn't know that, because it has to happen in this room. Up to this point, like I told you, like not to talk to people, that still applies. Anybody outside the jury, that's off limits. If we deliberate today, you went home tonight, came back tomorrow, the rule is especially important. You can't tell anybody anything at all. Once the case is done, you can, in case I forget to say that. With regard to deliberations, I've got 10 of you and 2 extras. So the 2 on the end, 17 and 19, you're alternates. So you don't deliberate, but you're not done. You're what we call insurance. There's no guarantee in an hour somebody's not going to get a call that they have to go, or that they hit the floor, or somebody had an accident, or the baby came early, or whatever it is. So you're not done. You're charged to not talk and to just wait. It's a luxury to have extras. I understand what I just did to you. I get it. But the number of times the jurors slot back in is not the majority, but it's enough that we're glad to have you for a reason. These folks get locked down and something happens along the way. We can't lose 3 days of trial work because somebody went through a stop sign or had a flat tire on a curvy road. Then all of a sudden you're back, we start all over, and the case gets done. So make sure the bailiff has your phone number. If you can be within like 15 minutes of the courthouse, I don't know what that means. If you live farther, just make sure Chris doesn't have to drive far to get you. He's not going to anyway, right? But he's big enough to, you don't want to cross him kind of guy. Anything you want me to deal with in the instructions, Mr. Klager?
I had 2 minor issues.
Okay, we'll talk over there. Mr. Osborne, you got anything?
I do have something, yes, sir.
Okay, we're just gonna see what I didn't do right, but we're close. The vote is 6 out of 8, not 8 out of 8. It's the next paragraph down. So I've got 8 jurors. When you go back there, 6 and 2 is a vote in favor or opposed. So you always have to have 3/4. So if you take a vote and it's 6 this way and 2 that way, that's enough votes. It does not have to be unanimous to prove a case. In a civil case, it's 6 out of 8. That big deal? Yeah. I forget it. Yes. It's 6 out of 8. So you can have 2 people say, I don't agree. And if 6 people do, that's a verdict. And then the emphasis for the 2 alternates is not only not talking is important, but not talking to the media is important. So if you get hounded, it's anybody in the universe because you're still in the panel. And then if the jury reached a verdict without you, that you're going to get a call saying you're done. And now if you want to talk about it, you can. Anything else, Mr. Klinger?
Nothing from us, Judge. Thank you.
Mr. Osborne?
Your Honor, I just renew any objections for the record, but nothing else I can add.
Fair enough. Overruled.
Thank
Or ruled, depending on what it did. There's a few typos. It'll be like 5-10 minutes before it gets you some sets of instructions. When you look at the instructions, if you have a question about something, read the whole paragraph, not just the one sentence. Like you always think, I want to know more about something. The answer might be 3 words, but read the whole paragraph to do it. So you start your deliberations. We'll get the exhibits back to you, cleaned up sets of instructions. And thank you for your attention so far.
When's lunch?
Yeah, are you taking our lunch order?
Sure am.
Seriously.
Shirley, we get their phone numbers.
Yes, I will.
I think you can see that way right there.
Read this later.
Yeah, and then, if you would have to come back and deliberate, you'll have to notice that. We don't look at them or anything, even afterwards. You wouldn't be able to follow them anyway. Remember, dear.